1 min ago, the Supreme Court did something Trump never expected it to do. It stopped him cold. With a single decision, the court blocked his final attempt to shield his financial records, and in doing so, it triggered a legal countdown that now carries a very real jail threat. This was not a delay. This was not a compromise. This was the highest court in the country saying no more. For months, Trump's entire strategy revolved around one assumption: that he could keep his financial records out of reach long enough for the pressure to fade. That assumption just collapsed. The Supreme Court did not issue a long, dramatic explanation. It did something far more dangerous for Trump. It let the lower court order stand. That silence is power. When the Supreme Court steps aside like this, it means enforcement moves forward immediately. Legal experts are already calling this a trap of Trump's own making. By fighting disclosure at every level, he narrowed his options until there were none left. The moment the court declined to intervene, the timeline snapped into place. Deadlines that were theoretical yesterday are now binding. Compliance is no longer optional, and defiance now carries consequences. This is why jail is suddenly part of the conversation. Not because of politics, not because of headlines, but because contempt law is brutally simple. When a court orders you to produce records and you refuse, the court does not argue. It enforces. Fines come first, then sanctions. And if resistance continues, detention becomes a tool, not a punishment, but a method to force compliance. What makes this moment even more serious is that these are financial records, not testimony, not opinions, not speech. Documents either exist or they do not. Courts have very little patience when someone claims they cannot produce records that are known to exist. That is why judges treat financial disclosures as a line you do not cross. Inside Trump's legal team, this ruling changes everything. There is no higher appeal. There is no procedural shield left. The Supreme Court just cleared the path and stepped aside. From here on out, every move Trump makes will be judged not by rhetoric, but by compliance. This is the moment where theory ends and enforcement begins. And once enforcement starts, the law moves faster than Trump ever has. What many people miss is that the Supreme Court did not need to say much to change everything. By refusing to block the order, the court effectively endorsed the lower court's authority to act immediately. In legal terms, silence at this level is final. There is nowhere else to go. Legal analysts explain that when the Supreme Court declines to intervene, it sends a clear message to trial judges: proceed without hesitation. That is exactly what makes this moment so risky for Trump. The enforcement clock is now fully in the hands of a lower court judge who already ruled that these records must be produced. This removes uncertainty. Judges are cautious when appeals are pending. They become decisive when appeals are exhausted. That shift just happened. Trump's legal strategy relied on constant escalation: appeal higher, delay longer, argue jurisdiction, challenge process. That approach only works as long as another court might step in. By pushing the fight all the way to the Supreme Court and losing, Trump eliminated the last buffer protecting him from enforcement. Legal experts describe this as self-trapping. Each appeal narrowed his options until refusal became the only remaining move, and refusal is the one option courts punish most aggressively. This is not about politics. It is about procedure. Courts tolerate argument. They do not tolerate defiance. Financial records occupy a special place in federal law. They are objective, they are traceable, and they are almost always verifiable through third parties. Judges know this. That is why courts treat claims of inability to produce records with deep skepticism. If banks, accountants, or institutions can supply the same documents, a refusal looks intentional. That is when contempt becomes unavoidable. Courts are far more willing to impose sanctions when documents exist independently of the defendant's cooperation. Contempt does not start with handcuffs. It starts with orders, then fines, then daily penalties. But if resistance continues, judges have one final tool: confinement. This is not punishment in the traditional sense. It is coercive detention. The court holds someone until they comply. The moment compliance happens, detention ends. That is why jail is now a real possibility. Not as revenge, not as symbolism, as leverage. Legal analysts emphasize that judges use this power sparingly, but they use it decisively when compliance is openly defied. Instead of signaling cooperation, Trump's public messaging has grown more aggressive, attacking courts, questioning legitimacy, and framing compliance as surrender all work against him. Judges pay attention to public conduct when it reflects intent. Statements suggesting refusal or defiance can be cited as evidence that non-compliance is willful. That distinction matters. Willful contempt invites harsher enforcement. Trump has faced court losses before. This one feels different because it removes distance. There is no future appeal to wait for, no political calendar to hide behind. Deadlines are now real. Consequences are immediate. This is enforcement territory, not argument territory. Legal observers say this is often the moment defendants realize the system is no longer debating them. It is acting. Inside Trump's legal circle, pressure is reportedly intense. Lawyers now face a binary choice: comply or face escalating sanctions that could spiral beyond control. No attorney wants to be responsible for advising defiance that leads to detention. That creates internal conflict and forces hard conversations. This is where legal strategy becomes crisis management. Supporters may protest, media may spin, none of it affects court orders. Federal enforcement moves forward regardless of public reaction. That separation is what makes this so dangerous for Trump politically and legally. The tools that once delayed consequences no longer apply. Courts operate on calendars, not polls. This is the reality Trump now faces. The Supreme Court stepped aside. The lower court is empowered. Financial records are due. If Trump complies, the legal risk shifts to what the documents reveal. If he refuses, the risk shifts to contempt and detention. Either way, the escape routes are gone. When the highest court clears the path and walks away, enforcement does not ask again. It moves.